mentioned, I've had several clients call and ask about the eviction moratoria that are currently in place. There currently is no statewide California moratorium governing all evictions. Instead, numerous local jurisdictions are adopting their own eviction moratoria that vary by city and county. Most of them extend through May 31 or until the expiration of the local state of emergency. But as I said, the expiration date varies by municipality. I expect that the expiration dates will be extended at least for another month. The bans apply to residential tenants and some commercial tenants, which are typically limited to small businesses and nonprofits. The definition of small business varies, but for example, the city of San Mateo defines a small business as a business with annual gross receipts of less than $25 million. It bans evictions for the non-payment of rent. The tenant can show that its inability to pay rent is due to financial impacts related to COVID-19. It also bans evictions for no-fault termination, such as possession beyond the expiration of the term, unless necessary for the health and safety of tenants, neighbors, or the landlord. In San Mateo and most other jurisdictions, the tenant has up to 180 days to pay the deferred rent from the date of the termination of the ordinance, which will likely coincide with the lifting of the local state of emergency. Some ordinances require the tenant to continue to show its inability to pay due to financial impacts related to COVID-19 in order to continue to defer rent beyond an initial period of time. Typically, if the landlord wants to commence unlawful detainer proceedings, the landlord must provide a prescribed notice and give the tenant 14 days to respond and provide reasons why its inability to pay rent is due to financial impacts related to COVID-19. Most jurisdictions are silent with respect to whether a landlord can draw on a security deposit. However, San Francisco recently clarified that landlords may draw down on security deposits if permitted by the lease. However, if a tenant is required to replenish the security deposit that the landlord has drawn from, and a tenant fails to do so because of the financial impacts of COVID-19, the tenant's failure to replenish the security deposit would not be a basis for eviction until 6 months after the moratorium expires. So what this all means is that a tenant may defer the payment of an installment of rent that is payable during the term of the ordinance for up to 180 days if failure to pay results from COVID-19. So, for example, if an ordinance was enacted in March and expires at the end of May, March, April, and May rent are covered and deferrable. If the ordinance is extended through June, so is June rent, and so on. Even if there is no moratorium in place, or it doesn't apply to a tenant, maybe because the tenant doesn't fall within the definition of a small business, a tenant still could take advantage of the court-imposed moratoria. On April 6th, the California Judicial Council essentially banned all California courts from carrying out any residential or commercial eviction proceeding until 90 days after the California state of emergency is lifted. Specifically, the court has banned the issuance of a summons or entry of a default judgment on a UD proceeding during this period of time. This also includes a 90-day stay on judicial foreclosures. But since nearly all deeds of trust are foreclosed non-judicially through a trustee's sale, the ban would typically not apply. Local courts have followed suit. In San Mateo, for example, the court imposed a court holiday through May 14th, which also likely will be extended. During this time, landlords may not file an unlawful detainer proceeding, no default may be entered in a pending proceeding, no writ of possession may be issued, and new UD trials will not be assigned until after May 21, which also will likely be extended.